Hello and welcome to That Encyclopedia Podcast with your hosts, Will and Jacob.
Hello.
So welcome again on this fine morning, evening, afternoon, wherever you are, to talk about the First Amendment. The First Amendment to the United States Constitution. Wow, what a big topic. And it is literally a big topic on Wikipedia. It's a very long page. Understandably, because it's quite a big deal. The First Amendment being the constitutional amendment that prevents the government from making laws that regulate the establishment of religion, that prohibit the free exercise of religion, infringe freedom of speech, freedom of the press, freedom of assembly, or the right to petition the government for redress of grievances. So it's quite a big one. I think people mostly recognise it or know it for freedom of speech or freedom of religion. And it is one of the 10 amendments that constitute what's known as the Bill of Rights. So it was adopted in 1791, and to this day, it is a political hot topic. I mean, how couldn't it be? You've all heard of discussion of freedom of speech somewhere, I'm sure, within the past year, let alone the past 200 since this was implemented into the United States. Yeah, what do you think about it?
Well, I think you've introduced it very well. The First Amendment to the United States Constitution is going to be a point of contention, I think, for American politics until the end of time, basically. Not the amendment itself, though. I don't think anyone has ever seriously argued or made any headway seriously arguing that the First Amendment is wrong in its intent or what it sets out to do. Rather, I think the arguments are more about where the limits of the First Amendment lie and to what extent it should be applied in private cases and to what extent it should be even applied in public cases, to be honest. The First Amendment, as you mentioned, is part of the Bill of Rights, the first 10, which are notable for all being published together as one single document. And the Bill of Rights was published actually not too long after the Constitution itself. So there was only a brief period in American history where the Constitution existed without it. Although it was ratified in 1791, it sort of existed for almost a couple of 2 years before then. It was created in 1789. I think that the text itself is worth reading in full, verbatim, because it's very, very short. All of this drama and hundreds of years of political theorizing and judicial scrutiny and lengthy legal opinions and interpretations have all stemmed from the ambiguity of the clause itself, which is only 2 lines, I would say, on a document. And it reads as follows: Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or of the right of the people peaceably to assemble, and to petition the government for a redress of grievances. Full stop. One sentence, split with appropriate semicolons and commas, but only one sentence, that's all it is. And it's one of the most important sentences in legal history, I would say. The 4 freedoms, 3 of them are established in the text itself, but subsequent Supreme Court rulings have also established the freedom of association, which is the ability to kind of form groups that are to engage in activities that themselves are protected by the First Amendment. So your ability to form advocacy groups, pressure groups, think tanks, that sort of thing. They're all First Amendment protected as well. It's an exciting one to be covering, I think. And the article itself is mostly a list of kind of famous court cases that have involved the First Amendment. So it's clearly something that has caught the attention of not just us browsing Wikipedia or listening to a podcast about Wikipedia articles, but of the whole American psyche over the past 200 years or so. Would you agree with that assessment, Will?
I think I would. I was just thinking, it's an interesting contrast, isn't it, between the First Amendment and the Second Amendment? Because, as you say, the First Amendment is not really controversial in the sense of its existence, but it is. They're both highly controversial amendments, but for completely different reasons, and they sort of focus on very, very different aspects of society as well. It's like, yeah, I feel like it speaks for itself, you know.
Yeah, absolutely. I think because it's such a short clause, let me point out the aspects of it that are, in my opinion, most important to keep in mind. Although, stressing again, we are not lawyers. None of this is legal advice, and in any case, this is only applicable to American jurisdictions anyway. But that said, I think there are a few key words in this line of text. The first thing to note is that because it's all one sentence, it all refers back to its subject, its linguistic subject, which is Congress. That first word is so important. Congress shall make no law. So really, it's broadly been interpreted as a public protection on freedom of speech, but private protection on speech is not as strong. So although it's a fundamental right, it's sort of a fundamental public right, meaning you don't have the absolute right to say literally anything you want in any situation. For example, if you are working at a private company and you just start spewing abuse at your colleagues and your bosses, you will get fired, and there is no First Amendment protection for that. If you attempt to incite violence to other people explicitly, that is not necessarily protected, as I understand, even if it is in a public place. Incitement to suicide is also not always protected under First Amendment rights. It's obviously extremely complex, but the broader point that I'm making, and I think the most important one, is that the word Congress explicitly constructs the First Amendment to the US Constitution as being designed to prevent government tyranny and government interference with freedom of thought, religion, expression, speech. The founders of the United States, whose leaders are referred to as the Founding Fathers, were acutely aware of the potential tyranny and overreach of governments. They had fled or otherwise rejected the authority of the British Empire at the time, under King George III, I want to say. There have been many King Georges. And having just overthrown their evil overlords, as they would see it, they were enthusiastic to design a single physical document that protected the rights of the newly liberated American people.
Question.
It is interesting that it was sort of forgotten from the original Constitution, though. You often see jokes that it's the first thing they remembered to put in after they realised they'd forgotten to put it in.
Yes.
But it was pretty quickly amended.
Question though, as you said, Congress shall make no law, but of course we're talking about a federation of states. So Congress shall make no law, but what does that say of individual states and their individual state laws?
Well, you've touched on an extremely complicated legal thing right at the bat. I could have a go at answering this. Is there something in the article that caught your attention that led to this question in particular?
There's a conflict, I think, in the language, as far as I understand it. For I've seen some examples from Supreme Court judges talking about the concept of the community not being able to legislate against this, that, and the other. But the word community is a lot more generic than the word Congress. And the word community could refer to a private community. So that leads me to be confused. Why didn't they just reuse the word Congress? And besides from that, I'm drawn to real-world examples of states exhibiting behaviour in modern times that I find extremely suspect if you were to say that this amendment ought to apply to them.
Well, I think the brief answer, and the one that I kind of would be most confident giving, because my confidence levels tail off pretty rapidly when discussing law in general, let alone American law. But the United States is politically a federal system, much like Germany or Australia, where government has, in general, 3 tiers. So you have your local government tier, which in America is normally your county, and then you have your state government tier. You normally have a state senate representing, for example, state congress sometimes, and then you have your federal level, which is what us internationals are most familiar with, the federal Congress, the federal Senate, and then of course the Supreme Court as well, that oversees the whole country. Individual states are sort of members of a club, and their legitimacy and importance to the overall system is reflected most prominently in the fact that every state, no matter its size, is eligible to send 2 senators to the federal Senate. This was an explicit design philosophy in the Constitution because it protects the rights of smaller states, at least in theory, against sort of just strong arming by larger states in terms of population and in terms of physical geographical size. So states have a lot of independence under the law. However, they are still ultimately bounded by the Constitution itself and by this original document. So my understanding is that states are not permitted to create laws that are unconstitutional, regardless of their other independence and freedoms. And if a state does make something that is challenged and makes its way all the way up to the Supreme Court, it's normally or frequently challenged on constitutional grounds, meaning that the plaintiff believes that one of their constitutional rights has been violated by the state, and they are looking for the federal government to step in and protect them. That is somewhat paradoxically what the judicial role of the federal government is, in many ways. Like, they are the managers of, firstly, foreign affairs, but then also they make sure that the individual states don't overstep. I think a lot of states, not to anthropomorphize political entities here, but I think a lot of states are very wary of government overreach and the federal government interfering in their quotidian business. But in cases that involve fundamental constitutional rights, that is exactly what the federal government exists to do, to protect Americans on American soil, regardless of their sort of immediate authority figures.
So I guess I just wanted to clarify that when it says Congress shall make no law, what you are suggesting is that it does not just mean that from henceforth the federal government should not be able to introduce new legislation that goes against this point, but that state governments also cannot make laws that go against the following points.
That's my understanding. Yes.
Okay.
Yeah, I believe so. I think it's any form of government, like American governmental body. That's my understanding.
Okay.
Yeah.
Okay. And that reminds me of another interesting thing that I read about it, which is, so not to say that this point on the word Congress and what Congress represents in the document is deliberately ambiguous, but on the topic of ambiguity, in the background to the First Amendment and the background to the Bill of Rights, James Madison, who was the drafter of the Bill of Rights and one of the founding fathers, had actually demonstrated an opposition to a list of rights that guarantees very specific civil liberties. And the reason he argued against this is that if you guarantee more specific civil liberties and enumerate these individual rights, it risks implying that other unnamed rights are unprotected by the Constitution. And so it sounds like he was a deliberate proponent of slightly ambiguous rules.
Yes, I agree. I thought that was a really interesting aspect of the article, actually, because I can see that point, and I hadn't considered it before. The ambiguity of the Constitution and the First Amendment in particular is a flashpoint for criticism, but actually there is this position that says we need it to be ambiguous because that gives it longevity. If we made it too specific, if we enabled it to have this degree of contemporary granularity, then it could become outdated, or it could become too narrow in scope. And the intention is to make it a timeless, broad protection, regardless of what happens in the future. So it does represent some forward planning by the founding fathers. They were, for all of their faults and criticisms you can levy against them collectively, they were not fools. They were legitimately passionate individuals, and most of them were veteran legislators and lawyers and policymakers and that sort of thing as well.
Although
I agree. Yeah.
In an attempt to argue with this notion, I could put forth that the issue with this ambiguity is that what if it just means that the implied rights, also how he refers to them, what if those implied rights cease to be perceived as implied in the future, right? I feel like what it can also lead to is massive division, disagreement, and flip-flopping of the Supreme Court, which we have, of course, seen with other parts of the Constitution. And at the end of the day, we might actually find that had his and other lawmakers' intentions been more clear, then there wouldn't have been so much flip-flopping over the perception of pre-existing constitutional rights, and it would have opened up more room for the government to make new laws in these gaps, which they might not be able to do in the current state of things. If that makes sense. I think
that's always the gamble. Yeah, no, it does. And I think that's always the gamble that you have to take to an extent, right? Like, founding documents, the Constitution and the Bill of Rights and subsequent amendments, really operate, I think, under this philosophy of trust in future generations, because they had to. Like, if they didn't trust those who came after them, then they were essentially assuming that the whole country was going to collapse a generation later. And so you have this inherent power balance between irrevocable words that are codified and explicit, versus the same words that are ambiguous, which affords the power of interpretation to judges and justices, particularly to Supreme Court justices. And the assumption really is that the Supreme Court is a neutral body. This is not really true. The degree to which it has sort of become less true as time goes on is a matter of some debate, but ultimately, because the Supreme Court is appointed through the executive branch, through the presidency, it is sort of, nominations have to be approved by the Senate, but like the Senate's an explicitly political, non-independent body as well, so it's sort of a moot point. But because the Supreme Court justices are appointed as political appointments, even if they, sort of pay lip service to the independence of their records, it more or less guarantees that over time the Supreme Court's interpretations are likely to change and flip-flop a little bit as the composition of justices' own political leanings changes and flip-flops over time. But yeah, it is a problem. I think it was definitely a foreseeable problem, but it's also perhaps better than the alternative. But I don't know. We don't live in a timeline where the document is like 5 paragraphs instead of 2 lines long, and everything is laid out in full. It would be interesting to see such a timeline.
I would
note as well that
or invite James Madison on the podcast to ask him how he thinks the modern legal system is dealing with it.
Yeah. Alas, he died in 1836, but maybe one day we could read his entire body of work, and then we'd be well on our way to becoming a Supreme Court justice, I'm sure. The other thing that I wanted to point out in the First Amendment text itself, and this is not something that I came up with or anything, this is actually something emphasised by former Supreme Court Justice John Paul Stevens, and this is organised under the second freedom, the freedom of speech and freedom of the press. He wrote in a journal article in 1993, quote, "I emphasise the word 'the' in the term 'the freedom of speech' because the definite article suggests that the draftsman intended to immunise a previously identified category or subset of speech," end quote. So what he's saying there is that because the text of the Constitution says the freedom of speech and not just freedom of speech, that the writers were explicitly trying to protect a certain kind of speech and not just the ability to speak whatever you want. Justice Stevens' particular example was that if you just protected the ability to say whatever the hell you wanted, then things like perjury in court, something a Supreme Court justice might care a lot about, would be protected unilaterally, and it would completely destroy the whole judicial system. So this sort of circles back to this idea of the freedom of speech being a well-defined right. And we've spoken a bit about the ambiguity of where those boundaries are, but perhaps we should also note, regardless of sort of whether you agree or not with particular borders, where the Supreme Court has ruled over time those borders ultimately lie.
Yeah, so just to reiterate that point you made, this part of the sentence prohibiting the free exercise thereof or abridging the freedom of speech. So we've got free exercise of freedom of speech, okay? It's not just free exercise of speech, as you say. So it's quite clearly referring to some other concept. Yeah.
Yeah.
So,
yeah.
What is freedom of speech today?
Well, freedom of speech today has undergone some interesting evolutions. In the history of the American judiciary, there have been some cases where it has been sort of overruled in a way that you might think or find surprising in the American context. Perhaps the most infamous example is the passing of the Espionage Act of 1917 in the States, which imposed a penalty of up to 20 years for anyone who caused, quote, insubordination, disloyalty, mutiny, or refusal of duty in the military or naval forces of the United States. And the American engagement with the First World War was not universally popular. And in 1919, the Supreme Court found and heard appeals from individuals who had been charged under the Espionage Act for distributing pamphlets that were sort of anti-war rhetoric. And in Schenck v. United States, an official of the Socialist Party of America called Mr. Charles Schenck had been convicted under this act for publishing these leaflets, which were specifically urging people to avoid the draft, to not be conscripted, which was a legal responsibility for adult men at the time. He argued that his conviction under the Espionage Act violated his free speech rights under the First Amendment, because he was just writing down his opinion and distributing them in pamphlets, both of which, generally speaking, are protected. However, the Supreme Court, I think surprisingly, unanimously rejected Schenck's appeal and affirmed his conviction. And writing in favour, Justice Oliver Wendell Holmes Jr. said that, quote, the question in every case is whether the words used are used in such circumstances and are of such a nature as to create a clear and present danger that they will bring about the substantive evils that Congress has a right to prevent. So the sort of limits of free speech, even with respect to government interference, are like, they do exist. And basically you're not able to advocate for things that incite lawless action, basically. This clear and present danger established, the clause that was established, interpretation that came about through this Schenck v. United States case in 1919 is sort of like a legal test for whether free speech, or the speech used, is indeed free and protected under the First Amendment, or whether it is incitement to imminent lawless action.
Well, I'm glad to hear that, because when I read the clear and present danger quote, I was a little concerned by, again, the ambiguity of the concept of clear and present danger, and how perhaps should enough Supreme Court justices view a particular thing, whatever that thing or behaviour is, as a danger, it would not have to be an illegal action or something with any sort of empirical proof of harm. It would just need to be a matter of opinion. But replacing that with the imminent lawless action at least requires the prior precedent of the perceived risk to create lawless action.
And I think, just as we come to the end, there are also, as a continuation of your question, there's plenty of room to regulate sort of speech that isn't specifically just an individual person expressing themselves in public, particularly in the context of commercial speech, for example. So advertising on television can have restrictions. The programs themselves can have restrictions, so you can't just have sex on children's TV, for example. There are limitations on pornography. You can have mass communications regulated pretty easily enough, and indeed several congressional acts have regulated mass communications, which I think are becoming a bit of a hot topic themselves with the rise of and possibly fall of social media over time. As I mentioned at the beginning, your employer can impose restrictions on free speech so that they can discharge their business effectively to a degree. If you're in the military, or if you're a legal professional, if you work as a prison warden, if you work as a border control agent, and maybe most famously, it's illegal to truly threaten the president. Under Title 18, Section 871 of the United States Code, it is illegal to knowingly and willfully make any threat to take the life of, to kidnap, or to inflict bodily harm upon the President of the United States. And this also applies to the President-elect, the Vice President, or any other officer next in the order of succession to the office of President or Vice President-elect. Those orders are basically the secretaries, so the President's cabinet, whom he or she appoints. So yeah, you can't make threats. It's a bit strange that the president is specifically protected, because my understanding is that if you're making a sincere threat against someone, you're sort of not protected anyway, because I would say that seems to be inciting lawless action regardless of who it is, but maybe it's only if you're inciting other people to lawless action and you are allowed to legitimately threaten to murder someone. I don't know. But yeah, there are plenty of exceptions to the First Amendment.
Yeah, and just some I won't go through it, but it's an interesting thing for any interested listeners to maybe go away and think about, or read the couple of paragraphs on, but where the concept of freedom of speech seems to differ away from speech itself. I mean, why is it here that the concept of desecrating the flag is considered an issue and a debate within the concept of freedom of speech and the First Amendment? I think that's interesting, as is the mention of the falsifying military awards, and even the section on campaign finance. So, interestingly, not just words but actions.
Absolutely. Yes, doing things that restrict the ability to perform free speech is also protected as well.
Anyway, that's about all we have time for today. And you can always learn more. There's plenty to learn on this topic, and you can educate us down in the comments section. One day we might make a responding to comments video. That would be interesting. But until then, see you next time.
Thank you very much. Take care.